Do you know what an arraignment is? I'm attorney Keith Wood and I'm a criminal defense lawyer in Louisiana. And in less than 5 minutes, I'm going to tell you what an arraignment is, why it's important, and the 4 things that generally happen at arraignments in felony court in Louisiana. Now, let's start with what is an arraignment? It's simple. It's the date after you've been arrested, you go to court to figure out what charges the prosecutor is going to bring against you in this case, if any. Now, why is that important? It actually works right into it, because an officer makes an arrest, and he makes an arrest based on his or her perceived facts and his or her perception of the law and what he or she believes they have probable cause to take you to jail for or give you a citation or summons for. But the next step is those reports and things go to the prosecutor's office, and someone in the prosecutor's office is going to decide what parts of that officer's report actually stick or don't. The prosecutor can keep all of the officer's charges as is if that prosecutor believes they fit. Or the prosecutor may say, well, some of these don't quite fit just right, and that prosecutor could decline some of those charges. Or maybe they replace it with charges that do fit. Maybe they look at the charges that you're arrested for and say, ooh, I can make this crime more specific and it would expose this defendant with more jail time or more prison time or a higher fine. But then again, maybe the prosecutor looks at it and says, ooh, I don't know if this fits just right, but I can make it more broad or choose a more broad crime. And then I may have less jail time or prison time threatening the defendant, but it's an easier case to prove. Now, let's talk about the 4 things that generally happen at a felony arraignment or could happen at a felony arraignment. Option number 1, you get to court. And if I'm your lawyer, I say, we are ready for arraignment. The prosecutor says, we're ready for arraignment too. We filed a bill of information and we've charged your client. At that point, I would say, as well as most any other criminal defense lawyer would say, we're going to waive reading of formal arraignment, enter pleas and not guilty to all charges, elect trial by judge or jury at a later date, and we need a hearing date too, please. Let's break those things down though. Waive reading of formal arraignment. Look, you don't need someone in the courtroom to stand up in front of God and everybody and say, are you this person? Is this your birth date? Are these the last 4 of your social? Well, the state is charging you with all of these crimes. No one needs to hear that. That's why you hire a lawyer, so that way that lawyer can explain those crimes to you and what it takes for them to actually be proven at a trial. The next part of that, enter a plea and not guilty. You don't walk in and plead guilty to something that you don't know when the state really has the facts or details to prove their case. So that's why you go to the next part, where you elect trial by judge or jury at a later date, because in Louisiana, if it's a non-capital offense, you can have a trial by judge only, but in misdemeanor court, you only have a trial by judge. Remember that for later. Finally, hearing date. You've got to get a copy of discovery to know what the state really has against you, if anything. You may need to file a motion to suppress. You may need to have a hearing on a preliminary examination. Those things happen at hearing dates, and that's why you get a hearing date at your arraignment date. But option number 2, you get to court and you and your lawyer say we're ready for arraignment, but the prosecutor says we are not ready for arraignment and we're giving you a new arraignment date. What this generally means is that the prosecutor needs more information before he or she can move forward with your case. Option number 3, you get to court. You say you're ready for arraignment, but the prosecutor says, we don't think it's a good felony, we're going to send it to misdemeanor. Here is your misdemeanor arraignment date. That's generally really good news, because when you can go from being at a felony level down to a misdemeanor level, probably a good day, really good direction for your case. Finally, the 4th and final thing that could happen in your case is you get to court and you say, we're ready for arraignment, but the state says, we are declining all charges. Doesn't happen often, but when it does, it's a great thing for you and your case, because now you know your case is over.